Our next file here is People of the State of Michigan versus Jonah Vaughn. File number is 25-3632FH. Appearances from counsel, please.
Thank you, Your Honor. David Denhoughton on behalf of the people.
Robert Hartzell from Mr. Vaughn, who joins us by Zoom from prison. Your Honor, I am filling in for Ms. Fiobento.
Thank you. Mr. Vaughn joins us again from a Department of Corrections facility via Zoom. Sir, are you able to see and hear the court?
Yes.
All right. Without getting into any details respecting the privacy of Ms. Fiobento, there was a family issue, and so that's why she's not here. I don't want you to think that you've been shoved off on somebody. It was something that popped up over the weekend, as far as I understand. So anyways, so we're here today for a final pretrial conference. Do we have a resolution?
I believe we do.
All right, Mr. Hartel, do you know what it is? Do you agree?
I agree, Your Honor.
Right, thank you. All right, so Mr. Vaughn, I'm going to hear from Mr. Denhoughton what he believes to be the resolution today, and we'll come right back to you. Yes, sir.
Thank you, Your Honor. It's my understanding that Mr. Vaughn will be accepting the people's offer, which is to plead to count 1, 2, and 3. Those counts are count 1, fleeing in the 3rd degree. Count 2 is resisting, obstructing, and count 3 is separate, resisting and obstructing. In exchange, count 4 would be dismissed, and importantly, the habitual 4th notice would also be dismissed. Now, as part of this plea agreement, just for the sake of context, the defendant is currently serving a prison sentence with an anticipated out date of May 21, 2027. So in terms of a kilobrew, we are agreeing that when the defendant is sentenced at that time, from that time forward, we would agree to concurrent sentencing. Now, as not a kilobrew agreement, it would be our recommendation to not, the people would at the time of sentence be arguing to not move the current out date for the defendant, but that's not a kilobrew. That would be our recommendation at the time of sentencing.
All right, that's a bit confusing, but I'm going to see if I can take a stab at this, repeating the words that I understand and make sure everybody else does. So regarding the sentence, and besides whatever the charges are, 1, 2, and 3 is pleading guilty to, dismissal of count 4, and dismissal of the 4th habitual enhancement. And when you say concurrent sentencing, so let's say we come back here in March. Do you mean give him credit for the time that he's serving, like in my mind, or?
So, so in terms of a kilobrew agreement, my understanding in terms of the law, because he's serving a current sentence, that legally, and obviously the court can make some sort of internal calculation, but what we're saying is that from the time of sentencing on, that this sentence would be concurrent with the time of his MDOC, which is what I think typically what the court does, and I think is legally allowed.
So, yeah, I got it. Yeah, I agree. All right, I just want to make sure I understood that. So if he gets sentenced, let's say, for example, on March 1st, I don't know if that's the date in which we're in court, that time runs concurrent with whatever he's serving. But what he's getting there right now, he doesn't get any credit.
That's correct, John.
Great, thank you. Mr. Hartel, is that what you understood?
Yes, along with just the recommendation still, but yes, Your Honor.
Yeah, I got it. All right, thank you. All right, Mr. Vaughn, have you heard what the attorneys have described to me as the pretrial agreement today?
Yes.
Is that how you wish to resolve it, sir?
Yes.
Please raise your right hand, sir. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
Thank you. Mr. Vaughn, looking back on this date of July 31st of 2025, which is the alleged date these offenses occurred, or allegedly occurred, I take it you must have been on parole at the time?
Yes, sir.
And is that, so you've been violated on parole and drawn back into the Department of Corrections for that, is that correct?
I am on the back on a new case. I had a gram of weed on me in Clare County Jail.
Okay, so you have multiple new cases, this one, and then the one out of Clare County that has caused you to be violated on your previous parole, and that's why you're there at the Department of Corrections. Did I get that right?
Yes, sir. Yes, sir.
All right, thank you. Were you on, back on that date, were you on bond pending any felony charges anywhere?
Yes, out of, Clare County.
Okay. So the Clare County one that you're there for a probation violation, you had a bond for that felony case, is that right?
Yes,
Have you already been convicted of that file?
I am now, yes.
Okay. So this is going to cause a little further explanation, which is perfectly fine because it shouldn't impact your deal. And I'll go over the deal in just a moment. What happens here is if you are on bond pending a felony case, and then you pick up a new felony, and sometimes there is what's called mandatory consecutive sentencing, and sometimes there is discretionary consecutive sentencing. So because you've been sentenced on that prior of that felony for which you were on bond, any sentence that I would give you here could, within the discretion of the court, run for that that marijuana case, sir.
20 months.
All right. So I could, within the discretion, within my discretion under the law, tack on any sentence here to the end of those 20 months. However, as I understand it, the agreement that Mr. Denhouten described to me is I'm not going to do that. Is that correct?
That is the agreement.
All right. I just want to make sure we're all on the same page. And unless it's a mandatory discretion, I'm sorry, not mandatory discretion, that's a redundant, that doesn't make sense. Unless it's mandatory, I probably wouldn't do it anyways, but all right. So let's talk about this plea. Count one is a charge of fleeing and eluding a police officer in the third degree. Now that is a felony punishable by up to 5 years and or up to $5,000 plus the Secretary of State would suspend your driver's license. Now there is a fourth habitual felony enhancement that could have increased that maximum punishment from up to 5 years to up to life. However, the enhancement will be dismissed. Count two and count three are both charges of assault, batter, wound, resist, obstruct, oppose, or endanger a Michigan State trooper. In each of those, the maximum punishment is up to 2 years and or up to $2,000. And because there is that fourth habitual enhancement, the maximum punishments could have been increased up to 15 years for each of those two counts. However, while you are pleading guilty to those two counts, the prosecutor agrees to dismiss the fourth habitual enhancement. Count four is a charge of reckless driving, which is a misdemeanor punishable by up to 93 days and or up to $500. That will be dismissed. So far, at least regarding the counts, is that what you understood to be the terms of your pretrial agreement?
Yes, sir.
Okay. Now there's another portion of this agreement that's called the Killebrew Agreement. And while you may be aware of it, I need to explain it to you. A Killebrew Agreement is a sentence agreement that you reach with the prosecutor. I am not a party to that agreement yet. I will decide at the time of sentencing whether or not I will follow it. Now, if I don't, you would have the right to withdraw your plea and then come back to this stage of the proceedings. Now, that Killebrew Agreement is that whatever sentence you receive, it will begin to run concurrent with whatever you're currently serving. In other words, that discretionary consecutive sentencing I talked about a minute ago, that's basically what this means. It's not going to be consecutive. It's agreeing that it's going to run concurrent from that date. Does that make sense, sir?
Yes, sir.
All right, thank you. Now, by entering the plea of guilty to these three counts, you will not have a trial of any kind. Does that make sense, sir?
Yes, sir.
That means you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Mr. Vaughn, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as they apply to this particular case?
Yes, sir.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would only otherwise be appealable if you were convicted at a trial. You also will be given up the right to come back and claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or that the plea was not of your own free choice. Mr. Vaughn, are you entering these pleas today of your own free choice?
Yes, sir.
Other than the terms of the pretrial agreement, which we went over, have there been any other promises, threats, or inducements to get you to plead guilty that we have not yet discussed today?
No, sir.
And I know we've talked about potential, well, actually, we didn't talk about the guidelines, but I trust that Ms. Firavento has talked to you about sentencing guidelines. I'll just highlight for you, as you may know, sentencing guidelines are not mandatory. They are a tool the court is required to use to establish a sentence, but we do not actually have to follow them. We just have to use them to try to establish a proportionate and reasonable sentence. Has anyone made any promises to you or suggestions as to exactly what a sentence would be from this court?
No, sir.
Now, have you had the opportunity to discuss all this with Ms. Firavento or Mr. Hartel?
Yep. Yes, sir.
And did he or she answer all your questions if you had any?
Yes, sir.
And were you satisfied with their advice, at least up until now?
Yep. Very much.
All right, good. Thank you. All right. Do you still wish to enter the pleas that we discussed earlier, sir?
Yes, sir.
Thank you. As to count 1, 2, and 3, how do you plead?
Guilty.
Before the court can accept those pleas, the court must have you tell me what it is that you did that makes you guilty of those offenses. Turning your attention to July 31st of 2025 in the city of McBain in Missaukee County. What happened?
I was being pulled over and I did not stop. And they followed almost to my residence. And when they got me in, my door was open and I had a pair of scissors in my hand and refused to be arrested. So
let's see if I get this correct. You were driving a vehicle on a public roadway. Is that correct?
yes, sir.
And you say they, you mean a couple of state troopers, or at least, was it one car or 2 cars?
One car.
Okay, and so was it a state trooper car, the blue with the cherry light on top?
Yes.
And did they turn on those lights or sirens, and in other words, try to give you direction to stop? All right,
Yes,
and you
sir.
saw those? I'm sorry, that's right. And you recognized that they were troopers trying to do their job to pull you over. Is that correct?
Yes, sir.
All right, but you did not stop the vehicle that you were driving. Is that correct?
Exactly.
Now, what makes this a flee and elude third versus a flee and elude fourth is the speed. Were you exceeding the speed limit in an area where the speed limit was 35 miles per hour or less?
I believe so, yes.
Where were you? Where was your house?
On the other side of Marion.
Yes, sir.
It was based on 2 bases.
Yep.
The court is right.
Uh-huh.
There was a section that was 35 or less, but also what might be a little bit easier is that
He had a previous one?
Yes, sir.
Yeah, that's the next question. Whether or not it was or wasn't, is it true that you also had a prior flee and elude over in I'm sorry, it was actually here in this county in front of me back on March 12th of 2021?
Yes, sir.
All right, thank you. Now, you said when you pulled into your driveway, you had a pair of scissors. What did you do with those?
I just grabbed them threatening to hurt myself.
All right, and so you were resisting those 2 police officers who were trying to take
Yes.
you into arrest?
Yes,
Okay,
sir.
thank you. All right, thanks. Mr. Denhon, do you believe he's provided a factual basis?
yes, sir.
Are you aware of any other promises, threats, or inducements?
No, you're right.
And do you believe that I've complied with Michigan Rule 6.302?
Yes, sir.
How about you, Mr. Hartel? Do you agree?
I agree.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that based upon the testimony made under oath on the record, satisfy the elements for the 3 counts. Therefore, the defendant is found guilty of count 1, 2, and 3. The case will now be set for sentencing, and at the sentencing, count 4 and the enhancements will be dismissed. Mr. Vaughn, I need to advise you, even though you probably already know, between now and then, we have to have a pre-sentence investigation report. Now, because you probably had, I know you've had prior ones, they'll basically take the most recent and they'll add to it. Now, that requires 3 things. They'll give you a packet, that meaning the Department of Corrections. You'll fill it out and turn it in. You'll also be subject to an interview, and you have the right to have one of your 2 attorneys present during the time of that interview. And number 3, your attorney must meet with you prior to us coming back to court, because he or she must go over that report, because each side has the right to come back to this court and request corrections, make objections to the scoring or objections to the content, because we want to make sure that it's complete and accurate before the court gets a sentence. Now, Mr. Vaughn, I say this often, I don't mean to be rude, but I don't like passing other people's junk forward. So if you get this PSI and prior courts or prior probation officers haven't filled out all the information correct, well, I want to correct it. So if it's on an old case and you didn't have a probation violation, it happened in a different county, speak about that with Ms. Fierabento, because I don't want to pass anything forward, because these reports follow people if there's an error and needs to be corrected. Do you have any questions, Mr. Vaughn, about what we have done today?
No, sir.
All right, thank you very much. Anything further, Mr. Deno?
No, Your Honor.
And Mr. Hartel?
No, Your Honor.
The court revokes bond and remands the defendant into custody. Of course, he's now earning credit. All right, thank you all very much. We are adjourned.
Hey, thanks for watching this clip from TCF Live. If you enjoyed it, please leave a comment, like, and subscribe if you haven't already. And you can join us weekdays live, 9 a.m. Eastern, 6 a.m. Pacific, right here on this channel.